I'm Ben Meiselas from the MeidasTouch network. Well, this was a pretty humiliating filing Donald Trump's lawyer, Joe Tacopina, had to make in federal court in the E. Jean Carroll case where Donald Trump lost, and E. Jean Carroll was awarded a $5 million jury verdict after the jury found that Donald Trump engaged in both battery as well as defamation. Here is the filing made by Joe Tacopina dated June 23rd, 2023, addressed to Judge Lewis Kaplan. Your Honor, we write to respectfully request that the court so order the enclosed stipulation and proposed order regarding the use of a cash deposit in court as security in lieu of a supersedeas bond. The cash deposit will be in the amount of $5,550,000, which is 111% of the judgment amount and is consistent with the traditional security percentage of supersedeas bonds. Additionally, my office is currently holding $5.55 million in trust and will promptly make such deposit upon the entering of this stipulation and order. We thank the court for its consideration. Signed, Joseph Tacopina. And as George Conway wrote in a post, he couldn't get a bond. Exactly right. George Conway, a very well-respected lawyer, pointing out here that Donald Trump was unable to actually secure a supersedeas bond from any company ostensibly in the United States that would be involved in the posting of such a bond. So here, what Donald Trump is requesting of Judge Lewis Kaplan, since nobody is willing to in any way provide any type of shorter relationship with Donald Trump at all, nobody's willing to do this. Donald Trump is posting $5.55 million himself in lieu of the bond, the supersedeas bond. Now, what's this even talking about? Why is he posting this bond? When you lose a court case and you file an appeal, you have to post a bond in order to pursue an appeal, and the bond that you post has to usually be equal to or greater than the underlying jury verdict, the judgment that has been entered against the other party, in order for you to pursue an appeal. So here, the jury awarded E. Jean Carroll $5 million for Donald Trump engaging in sexual assault, as well as for defamation of character. And as a result, Donald Trump would have to post a bond in New York. It's usually equal to about 110 or slightly more percent. And normally you would get a supersedeas bond. But here Donald Trump was unable to secure a bond. So his lawyer, Joe Tacopina, is saying that the $5.55 million is currently in his trust account, and that money will be deposited if this arrangement is approved with the court. So now Judge Lewis Kaplan has to rule on the requested stipulation, and one of the things that we may see from E. Jean Carroll's lawyer, although I don't know if they're going to go in this direction, because they may think the judge on its own will question the source of these funds, but will E. Jean Carroll object to this arrangement? Will E. Jean Carroll request that the court provide or order Donald Trump to provide information about the source of these funds? Is this coming from the Trump organization, a organization that has been convicted as a felon in a prior Manhattan District Attorney case? One of the reasons it's not going to be able to get a bond, the organization is a felon. Is this money coming out of Donald Trump's money directly? I highly doubt it. Is this money coming from one of Donald Trump's political action organizations, the Save America thing, or one of the other organizations? will E. Jean Carroll's lawyers file a motion to say, give us the source of these funds? What is Judge Lewis Kaplan going to do? On the one hand, Judge Lewis Kaplan can very easily just accept the source of the funds and say, look, whether it's a supersedeas bond or cash that's being deposited with the court in the amount of $5.55 million, I'll just, it's fine. You know, you could pursue your appeal. Or is Judge Kaplan going to inquire, have you tried to get a supersedeas bond? Where's the source of these funds? Because the court doesn't want to be involved in the commission of any criminal conduct. We know that the Save America PAC, for example, and some of these other Trump organizations are under criminal investigation right now in the Southern District of New York, in the same federal courthouse. For example, we know that while the Save America PAC is under investigation in Washington, D.C. federal court as part of special counsel Jack Smith's investigation into potential money laundering and wire fraud, in the Southern District of New York, Trump Media, as well as the Digital World Acquisition Company, they're under investigation out of SDNY. So Judge Lewis Kaplan is a federal judge in SDNY, Southern District of New York. So is he going to have concerns knowing that that's taking place, what the source of these funds are? But this is probably, you know, the second most embarrassing filing that Trump's made in the past 2 or 3 weeks in this case. You know, the other one's not only embarrassing, you know, to the legal system that Joe Tacopina would even write such a thing, but it's downright disgusting. I want to talk about what that other motion was. So one of the things that Joe Tacopina filed was a motion to try to overturn the jury's award of $5 million, arguing that because the jury only found that Donald Trump engaged in sexual assault, that only was the argument, as disgusting as that is. Because the jury only reached that conclusion, as though that's an only, it's absolutely not. Therefore, the amount they awarded of $5 million was too high. So they're seeking this motion with the trial judge to reduce the jury verdict. At the same time, they filed a notice of appeal with the Second Circuit Court of Appeals, but they had to post a supersedeas bond. And E. Jean Carroll's lawyers fired back in a filing this week. And let me just read you this preliminary statement because, wow, it is powerful. E. Jean Carroll's lawyer, Roberta Kaplan, no relation to Judge Kaplan, writes the following. Over the course of 2.5 days of trial testimony, E. Jean Carroll spoke clearly, powerfully, and courageously about the harms caused by Donald J. Trump when he sexually assaulted her more than 25 years ago in a dressing room at Bergdorf Goodman and then lied about her publicly in October 2022. Two experts, one on psychological harms and the other on defamation damages, backed her testimony with credible and reliable analysis. The jury considered that evidence carefully, and ultimately the jury concluded that Carroll was telling the truth and Trump was not, finding that Trump had sexually abused and later defamed Carroll and awarded her $5 million in damages. Importantly, on this motion, Donald Trump and his lawyers do not seek to disturb the jury verdict on its merits. Rather, Trump takes issue with the amount of money that the jury awarded Carroll as damages. But Trump's motion is nothing more than his latest effort to obfuscate the import of the jury's verdict by engaging in his own particular Trump-branded form of magical thinking. Once again, Trump has the nerve to claim public vindication from the jury in this case, when in fact the jury determined he penetrated Carroll's vagina with his fingers without her consent and then defamed her last year. His factual representations about what happened at trial are only compounded by the legal errors in his brief, both in articulating how courts have applied the relevant standards to assess battery and defamation jury awards, and in suggesting how those standards should apply to the damages awarded here. As explained further below, the court should reject Trump's request either for a new trial on damages or for the court to decrease on its own the amount the jury determined that Trump now owes. And just to leave you with this one thought. So why do you have this supersedeas bond, or why do you have this money that's deposited? because immediately if the Court of Appeals rejects the appeal, that $5 million goes immediately to E. Jean Carroll. So it's a way, basically, I mean, there's technically an ability to appeal to the Supreme Court, but it's not a case the Supreme Court would ever hear. But then the money goes right away, and this way the litigant, the plaintiff who prevailed in the case, is now aware that they'll be able to collect their money, and the court will allow the appeal system to hear the case so that the appeal system is not being abused as a delay tactic or as a way to try to shield and hide money. That's what's going on there. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We are on our way to 1.5 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch. And wherever you get podcasts, subscribe to the MeidasTouch podcast and have a great day. Hit subscribe on YouTube now.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.